Welcome to S&C's Critical Insights. I'm Alex Gross, a partner in the firm's litigation group, part of the IP and antitrust groups. Annie Ostrager, a partner in the firm's litigation group, one of the co-heads of our employment law group, and I are going to continue our conversation on a range of trade secret issues impacting our clients. Sabrina Solow, an associate in our litigation group, will moderate this discussion, which is our final episode in a 5-part series on trade secrets. Tune into our prior episodes to hear our conversation of the relevant legal background for trade secret matters, on the litigation landscape, on the interplay between trade secrets and non-compete agreements, and on what companies can do to minimize the risk that they become involved in a trade secret dispute. Today, we're going to discuss considerations for companies that are bringing or defending against allegations of trade secret misappropriation. This includes the role of injunctive relief, the impact of mandatory disclosure regimes, and internal investigations to inform an analysis of the litigation risks and benefits. With that, I'll turn it over to Sabrina to get us started with today's conversation.
Thanks, Alex. Can you start us off with a discussion on step 0 in a dispute? Specifically, how and why an internal investigation might arise, and how that investigation might inform analysis of litigation risks and benefits?
Happy to. As we previewed, the defendant in a trade secret case should immediately conduct a robust investigation into the allegations that it or an employee has misappropriated a trade secret. Depending on the circumstances and the specific allegations, these types of investigations may require reviewing vast amounts of documents, interviewing multiple employees, or, where appropriate, consulting with industry or technical experts. And these investigations may need to be completed in a very short period of time so the company can make strategic litigation decisions with full knowledge of the relevant facts. Given the broad scope and expedited nature that these types of reviews often require, companies should engage a law firm that specializes in these types of investigations, like S&C.
Thanks, Alex. Annie, anything you'd like to add?
Well, I agree with everything that Alex said, and the three of us have substantial experience conducting exactly that type of investigation. And it's one of the advantages that we have with our interdisciplinary practice to be able to conduct these investigations that precede a litigation in this space, but which are inextricably linked together. And the investigation will have important consequences for the way a litigation is conducted, if that's the way this goes. These investigations may also lead to a pre-litigation letter, which could take the form of a cease and desist. It can also take the form of a reminder to the employee or former employee of contractual obligations. And next steps will really be informed by the findings of that investigation. So can the company actually determine that there has been misappropriation? Is it more a concern that there's a risk? Is it something that's tied to our non-compete discussion and sort of we haven't found that there's been misappropriation? Is it reflected in documents? And all of that will drive next steps and potential litigation. Are you going to ask for an accounting? What other measures are you going to ask for that may head off litigation if that's possible?
Thanks. Let's discuss what happens next, after the internal investigation, when a party is bringing or defending litigation. What are some factors that a party should consider when bringing the action?
I'll start by mentioning 3. So first, what are the claims going to be? That's an important analysis that has to take place before you proceed. What's the appropriate forum? Meaning, is this a federal case? Do you have defend trade secret claims that we talked about in an earlier episode? Is this a state issue? If so, what state? What's the appropriate place? Are there arbitration obligations that are in play that may feature in an employee's contract or otherwise? And then what are potential counterclaims? So first, a party seeking to recover for alleged misappropriation of trade secrets shouldn't necessarily confine itself merely to recovery under the DTSA or state trade secret laws. The party may also wish to consider additional claims when applicable, such as civil conspiracy claims, breach of contract, or tortious interference with a contract. And then second, on the forum part, a defendant in a dispute arising under the DTSA or UTSA could find itself in either federal or state court. So the employment agreement may also contain a arbitration clause, and then you have to factor that in too. And then finally, it's important for a party seeking to recover for alleged misappropriation to consider relevant statutes of limitation for bringing related claims and the strategic ramifications of whether you want to add in those claims or not.
Thanks, Annie. With that in mind, Alex, what about factors that a party should consider when it is named in a complaint alleging trade secret misappropriation?
Sure. So Annie went through three considerations for bringing an action. So I'll talk through three considerations for companies to think through when they receive a trade secret complaint or the type of pre-notice letter Annie was talking about earlier. So first, as I discussed earlier, the defendant should undertake a robust investigation to fully understand the facts relevant to the allegations and the claims in the complaint. Second, the defendant may consider whether it has any counterclaims or defenses. Counterclaims in particular can be important because they can help create leverage for a potential settlement. Topics that companies should consider include whether it might have its own intellectual property, including trade secrets or other forms of intellectual property like patents or copyrights that it might assert against the party that filed the litigation, or whether it has the other types of claims that Annie was talking through, state law claims for breach of contract or tort claims, or depending on the state, claims for unfair competition. And companies should really give a lot of thought to the full scope of potential counterclaims and whether those counterclaims make sense in the context of the litigation. Third, where appropriate, the defendant may move to dismiss for failure to state a claim under Federal Rule of Civil Procedure 12b-6 or under state law equivalents if the case is pending in state court. We'll discuss motion to dismiss arguments in more detail in a moment, but the defendant may also consider other grounds it has that may result in the dismissal of the complaint, including issues like lack of standing or lack of personal jurisdiction.
Thanks, Alex. Annie, could you summarize the relevant pleading standard a defendant should note when considering a motion to dismiss?
Yes, sure. So Alex mentioned 12b-6 and state law equivalents. That's the regime that governs motions to dismiss, which are really important in all cases, but in the trade secrets case can really help you short circuit what can be a burdensome discovery process and a long protracted litigation. So the standard at the highest level is the same as it is for any other 12b-6 motion, but there is a lot of disagreement around what you need to plead to satisfy that standard in a trade secrets case. In the Southern District specifically, since that's where we are, there are cases going both ways in terms of the level of specificity with which a plaintiff has to describe the at-issue trade secrets in their complaint. And this is something that we could see percolating up to the Second Circuit. But at this time, that court hasn't articulated the precise contours of how the specificity requirement plays out in the context of a trade secrets case. And of course, that makes a huge difference in this context because, as we talked about in some of our earlier episodes, what is a trade secret and how you articulate it is really at the core of all of these cases. So just to give an example, in a case called Harley Marine v. Moore, and in Zurich American Life Insurance v. Nagel, courts in the Southern District agreed that a complaint that only claims general categories of information and data as trade secrets does not state a claim under the DTSA because it doesn't adequately put the defendant on sufficient notice of the contours of the claim of misappropriation, meaning it doesn't really tell the other side what the specific trade secret is that's allegedly been misappropriated. It's too broad, it's too general. On the other hand, there are courts in the Southern District that have found high-level pleadings for that kind of categorical nature to be enough. For instance, in Medidata Solutions versus Viva Systems, the court found a complaint had sufficiently identified the trade secrets at issue because the plaintiff provided categories of information, and therefore the defendant, that court found, had adequate notice of the trade secret allegations against it. And even within that dispute, You could imagine that that will be a more nuanced discussion depending on how many trade secrets we're talking about, what the nature of the alleged trade secret is, what the industry is. And so courts will consider all of those factors in determining whether there's been sufficient pleading under 12b6 or a state law equivalent.
One thing you said, Annie, made me think of a related topic that I think some of our listeners may be interested in, which is you mentioned that a motion to dismiss may avoid burdensome or costly discovery. One other really important issue to consider at the outset is whether, depending on what jurisdiction and what court you're in, you may have arguments to stay discovery pending the decision on the motion to dismiss, or at least to limit discovery into certain categories of information. And we've seen cases and had experience doing that ourselves where courts have either stayed discovery or have limited discovery into the specific trade secrets at issue, but not into the defendant's broader business. And given the burden that discovery can impose on a company, it's often very important to attempt to either kick the can down the road until after you receive a decision on the motion to dismiss, or at least minimize the amount of discovery that a company has to provide until the court has ruled on whether or not the claim can go forward as a matter of law.
Yes, I completely agree with that. And in addition to the usual burden arguments that are at play in every case when discovery kicks off, here the whole case is about whether highly confidential, sensitive, trade secret business information has been misappropriated. So typically, the defendant and the parties in a litigation like that will not want their competitors roving through their business records.
Thank you both. Alex, let's touch briefly on a topic you and I discussed in the hallway here in the past few months, the crucial role played by injunctive relief.
Yeah, and this is a really important topic for any company that's involved in a trade secret dispute, both companies seeking to protect their trade secrets and also companies facing allegations of trade secret misappropriation. An injunction, of course, prevents further disclosure or use of the alleged trade secrets and comes in two flavors: preliminary injunctions sought at the beginning of the case and permanent injunctions sought after trial. So I'll start with preliminary injunctive relief. Under New York law, to receive a preliminary injunction, the party must establish three elements. First, the party must establish irreparable harm, meaning harm that cannot be cured through monetary damages. Second, the party must either establish a likelihood of success on the merits, which is the more common way to satisfy this prong, or show that there's a sufficiently serious question going to the merits of its claims that make it a fair ground for litigation. And in either case, the party must also show the balance of the hardships favors a preliminary injunction. The third element that parties seeking preliminary injunctive relief must satisfy is that the preliminary injunction is in the public interest. In a recent case in the Eastern District of New York, Hercules Pharmaceuticals versus Cherna is an interesting example here that touches on some of the issues we've discussed in earlier episodes about the interplay between trade secret litigation and non-compete agreements. In that case, the court concluded that irreparable harm existed because the plaintiff had produced evidence showing that the defendant had already divulged some of the plaintiff's confidential pricing information to his new company in violation of the non-compete agreement with the former company. The preliminary injunction motion was appealed, so this is something we'll continue to monitor as it relates to the interplay between preliminary injunctive relief and non-compete agreements.
Annie, how do non-compete agreements bear on this irreparable injury inquiry?
Yeah, this is an important point, and I agree with Alex that this comes up a lot in these types of cases. Claims of irreparable injury can be supported by language in non-competes, and when we're drafting them, we usually put that in, but it's usually not going to be enough. It's going to be one factor that courts look to and consider. In a recent SDNY decision, the court observed that courts frequently find that damage to customer relationships stemming from disregard of non-compete or non-solicit covenants will cause irreparable harm. But the Second Circuit has been clear that district courts cannot automatically assume irreparable injury. So having the language is good and helpful, but not necessarily sufficient for a court to find that there's been irreparable injury. And similarly, as we've talked about, the fact that there is no non-compete isn't going to be a bar to getting this type of relief if you can make the showing that Alex described.
Interesting. Alex, what about permanent injunctive relief?
So I'll keep it quick here. Permanent injunctive relief is available as a remedy under both the DTSA and state law. To obtain an injunction in trade secret cases, the plaintiff must establish the typical four requirements set out in the Supreme Court's eBay decision, which can be a high bar. Parties should also consider the interplay between injunctive and monetary relief. For example, in a previous episode, we discussed the Second Circuit's decision in Sintel, in which the court had declined to award unjust enrichment damages under a theory of avoided costs because the court already had awarded lost profits to account for past harm and had entered an injunction against future use. And so in that case, the plaintiff was unable to claim the much larger amount of damages it was seeking under a theory of avoided costs, and instead had to settle for the much smaller lost profits damages award because it had sought an injunction. And so early in the case, companies should think about what forms of remedies they're requesting, both monetary and within monetary damages, the different types of damages and the components of them, and whether they address future harm or past harm, and should make the decision about whether to seek an injunction in the context of the other types of monetary relief that a party is requesting.
All right, let's conclude our final episode.
Okay, so I think takeaways are that there are a variety of strategic considerations for a company that is involved in or may become involved in a trade secrets litigation. A party contemplating bringing a trade secret misappropriation claim should do some internal legwork before it does that, should strategize about what its end game is, may want to assess its own reasonable measures that we talked about and other things that are going to bear on the case going forward if it brings it. It should be aware of relevant federal and state law standards, the relevant pleading standard, which we talked about, discovery obligations it's going to have, including and importantly, at what stage of the litigation it's going to have to disclose the purported trade secrets and with what degree of specificity, whether any related claims are appropriate and should be added on to any trade secret claims. And then, of course, as Alex was just discussing, the critical role played by injunctive relief in terms of preventing further misuse and misappropriation. And it's important to have experienced counsel who can guide a company through all of these decisions and through the pre and during litigation landscape.
I agree. And for parties defending against trade secret misappropriation claims, as we discussed earlier, companies should immediately perform a robust investigation to determine the scope of the problem, if any, and take appropriate remedial actions. And there, as Annie was just discussing, it's really important to have experienced counsel who can get up to speed on the issues very quickly and perform a deep investigation in often a short period of time. Defendants in trade secret misappropriation cases also need to be aware of the law in the relevant jurisdiction, which can inform important strategic decisions like arguments made in support of motions to dismiss and when to insist that the plaintiff specifically identify its trade secrets. Defendants also should consider counterclaims and proactively build a record to argue that the alleged trade secrets do not meet the distinct requirements for trade secret protection that we discussed in an earlier episode, and that injunctive relief is not appropriate. Finally, as Annie mentioned, companies that find themselves named as a defendant in a trade secret complaint should immediately consult with experienced counsel to work through these complex considerations and set themselves up to vigorously defend against the complaint.
Thank you for listening to the final S&C Critical Insights episode of our 5-part series on trade secret disputes. For more information about our practice, please visit us on the web at www.solcrom.com.